Hello friends, Namaskaram, how are you? Myself is Dr. Jinesh Soni. I am an advocate. In today's live seminar, we will discuss an important concern concerning the check cases. In the daily practice, it has observed to me that despite of having compromise, the complainant if fails to withdraw the case, the concerned accused has to face the consequences. So basically, we have to understand the problem. Then we will discuss the modus so that we could have the proper solution on record. If you really want to update your information or knowledge on the subject, I request all of you to maintain a proper notebook with pen or pencil so that if you are having trouble, the set guidelines or the legal position so maintained by you would be the guiding principles. Whenever there is a case against you concerning the check bounce, the concerned complainant will file a case under section 138 of NI Act. Usually when the case is filed by the bank, there might be a compromise between you and concerned bank. The bank official usually asks you that to execute the proper compromise, you have to come to the office of bank so that a proper agreement could be executed. And ultimately, after having the proper compromise, we will withdraw the case. By believing on their word, you used to visit their office. At office, the documents are executed regarding the compromise, and ultimately you pay off the certain amount. And after that, NOC is given to you by the concerned bank. At that time, assurance is given to you by the concerned manager of bank that the case of section 138 of NI Act will be withdrawn by us. There is no need to worry, there is no need to go to the concerned court. By believing on their words, when you fail to go, and ultimately when court requires you, they fail to inform even to the concerned court about the fatum of compromise. In that scenario, to ensure your presence, the court may issue the proclaimed warrant, means the court may declare you the proclaimed offender. In that scenario, you might be in the hot water, because in consequence of which even you could be arrested. So basically what we have to do to avoid the sad panic scenario, first of all, I want to clarify you that if there is a compromise between you and concerned parties, means the concerned bank, in that scenario, you are supposed to execute the proper agreement. In the agreement, please note down each and everything by the virtue of which the concerned case could be disposed of. The terms and conditions must be clear, must be specific. For example, if the case is concerned with a check of rupees 10 lakh and compromise amount is rupees 5 lakh, you have to specify that the said amount is given to discharge the whole liability. It is not the part payment. If you fail to execute the agreement in the proper way, and even it is executed in the routine way, in that scenario, you have to face the consequences, because once the agreement is executed, it is duly signed by you, you are bound by the content of said agreement. And that's why I request all of you, just read the entire agreement before signing it. In addition to this, the studies further says that there are certain cases wherein the amount has been fixed, but certain amount is paid and the remaining amount is not paid. Even in that scenario, the concerned bank failed to inform to the concerned court regarding the compromise, and the same scenario may occur. In both the situations, when there is a compromise, there is an agreement, can you do one thing? Can you go to the concerned court along with the complainant so that the agreement could be on record? If the agreement is on record, the amount is paid in whole, the court will refer the matter to the concerned Lok Adalat. To avoid the further panic of such scenarios, I have specified you the basic protocol. Now it depends on you whether you want to face them or you want to adopt the specific approach by the virtue of which we could avoid the same. I am going to specify you one of the most important judgment of Honorable Punjab and Haryana High Court, wherein the said scenario occurs. The accused has been declared proclaimed offender and he was in panic. And it is called the psychology of the concerned accused because whenever there is a proceeding by the court, in consequence of which he is having the apprehension of being arrested, he might be in panic. First of all, there is no need to surrender before concerned police or before concerned court. First, take the certified copy of entire file. Just read the proceedings whether the concerned judge has followed the due approach to declare you proclaimed offender or not. The guideline says that the mandate of BNSS or CRPC is required to be followed. There must be satisfaction on record that the accused is evading the process. Even the publication of the proclamation is must. If protocols are not followed in routine way, the order has been passed, the order would be illegal. You may challenge the order so that the chance of being arrested could be minimized and could be avoided. And if the argument is based on the framework that the proceedings are done in the routine way, the mandate of law is not followed, in that scenario, the order is liable to be set aside, as observed by Honorable Punjab and Haryana High Court in the case which I specified to you. In that case, the said scenario occurs and finally the accused got remedy. Judgment is passed on 11th of Feb 2026. So if you are having the trouble and inter alia the compromise is not submitted, so on the basis of factual score, you may proceed before Honorable High Court and could get remedy. So in conclusive way, we have to understand that each and every time when there is a compromise between you and concerned bank, mention the fatum of compromise before the concerned court. And in case you fail to specify, there might be a possibility of proclaimed offender. So to avoid the same and to revoke the same, I specify to you what you could do so that the entire panic, entire anxiety could be resolved and could be rid of.